Welcome and thank you for joining today's Seyfarth webinar. Now what? Midwest State of Employment, what's in store in 2021. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature located on the right side of your WebEx window. We will do our best to get to everyone's questions. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and it is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to Chris DeGroff. Chris, you may begin.
Thank you. And good morning all from snowy Chicago. Again, this is Chris DeGroff, and Aaron Foley and I chair the Labor and Employment Department here in Chicago. Wish we could be doing this live, but soon enough, we're getting there. We're very excited that you all could join us for this Midwest-focused update. We all know that the Midwest is a really interesting mix of jurisdictions with all manner of political leanings and legislatures and demographics, urban, rural. It's quite a mix. And that makes your jobs obviously far more complex. We'll use that word for it. So hopefully today helps you see around some corners and keeps you ahead of all that complexity. But that's it for me. I'm going to turn it over to Aaron and enjoy the presentation today.
Thanks, Chris. Good morning, everyone. Thanks for joining us again. Appreciate you taking the time this morning. We're excited to have you join us for our Q1 breakfast briefing. For those of you who are regulars to this program, and I've seen some familiar faces, or at least some familiar names on the sign-in sheet, you'll know that at this time last year, a year ago and an extra week, was the last of the breakfast briefings that we were able to do live and in person. And then those of you that were there, remember that we took it on the road. We were out in Rosemont. It was a beautiful day. And so it holds a fond memory for myself, Meg Toth, and the other speakers that were there that day. So thank you for being with us virtually today. And what a difference a year makes, right? So let's maybe take a pause and reflect on the year for a second. Give yourself a pat on the back for having made it through this far. And we're happy and excited to present to you guys this morning. We've got a great lineup of 5 of my amazing colleagues to showcase what's been going on in the Midwest and what we expect to see in the course of the next couple months. We thought that was fitting in light of Women's History Month and International Women's Day just last week. So I'm very excited to have you listen to my 5 amazing colleagues. We've got about an hour's worth of content for you, a little bit more than that this morning. And then there will be a Q&A session at the end. So as Julianne just mentioned, if you do have a question, go ahead and just write it in at the time that the speaker is talking about it. And at the end of the presentation, substantive presentation, we'll come back to the questions themselves. And as Julianne also mentioned, there's CLE, so please hang on until near the end. We will be reading that code out. And if you have any questions or have any technical difficulties, you can also use the chat function during the presentation as well. So with that, I'm excited to kick it over to Meg Toth, and hope you all enjoy your programs. Grab your coffee and let's have a good time.
Thank you, Erin. I've successfully unmuted myself, maybe for the first time in a year. Good morning, everyone. As Erin said, we have a jam-packed agenda today. I'm going to be kicking us off with the first topic, which is important Midwest employment law updates in 2021 and beyond. If you could go to the next slide, that would be great. I'm going to be addressing a few different topics today that may not be as on the forefront of everyone's mind with the distractions of COVID, but are equally as important not to be missed by any of you out there with Midwest employees. So these topics include sexual harassment training and reporting requirements in Illinois. There's a new discrimination law in Ohio. There's a predictive scheduling law that came into effect in Chicago, as well as one pending in Illinois at the state level. There are new various ban the box laws as well as some amendments to the current ban the box laws in Illinois, as well as a new pay reporting requirement in Illinois. And on this last topic, well, it is very worthy of mentioning and important to be aware of, as we believe it's likely to be passed and impose new pay reporting requirements on Illinois employees. I'm not going to spend too much time there because next week on March 24th, which is Equal Pay Day, some of our colleagues, including Christine, who's here with us today, will be presenting on this very topic. So if you're interested in learning more about that, you should tune in for that webinar next week. Okay, so moving on to the next slide. As many of you hopefully are aware, Illinois last year in 2020 has new sexual harassment training requirements as well as new reporting requirements. We did want to touch, even though these were imposed or, in effect last year, we did want to touch on these briefly because both actually have annual reporting requirements. So, while it's very important to make sure you've complied with what was required in 2020, there are also requirements coming up this year that everybody should be aware of. So, in terms of the training requirements, all employers in Illinois were required to train all of their employees by December 31st of 2020, and then each calendar year thereafter training is required. This includes all employees, short-term, part-time, interns, not independent contractors. So there is a broad group of people that are required, and to some extent, it actually includes employees that are not necessarily physically sitting in Illinois, but it may interact with your Illinois workforce. So it's very important to pay close attention to who you're required to train. And then there is specific training content that is required. It's not as, I would say unique as some other state laws we see, but very important to make sure you do include in any training that you're doing the state required content. And there is a model training that you can use or look at to make sure you're complying in that regard. Now, the reporting requirement that came into effect last year requires Illinois employers report the total number of adverse judgments or administrative rulings finding sexual harassment or unlawful discrimination the preceding year. So our first deadline was to do that reporting was October 31st, 2020. And then each year thereafter on July 1st, you are also required to report those adverse administrative rulings or adverse judgments. This applies to private employers who employ one or more employee in Illinois. So again, broad coverage. And it also includes adverse judgments or administrative rulings that have been entered into outside of Illinois that meet the definition, which means any final non-appealable judgment that finds sexual harassment or unlawful discrimination where the ruling is in the employee's favor against an employer. So very important to figure out if you have any adverse judgments or administrative rulings, which fall within the reporting requirements. And there is a form found online that can be filled out and submitted with more detailed instructions on how to meet your obligation. Okay, moving on to the next slide. And our next topic is the new Ohio discrimination law. This is called the Employment Law Uniformity Act. It was signed, this was a bill that was signed into law in January and becomes effective in mid-April of this year. This is a law that actually is helpful for employers, and it has a lot of important provisions and, sort of helps our employers in Ohio to better align the Ohio law with federal law and standards and other state laws across the country. The important provisions include a new 2-year statute of limitations to bring discrimination claims. It used to be 6 years, which was the longest in the country. It also requires that employees exhaust their administrative remedies before filing a lawsuit in state court, which means you must file, or employees must file, a charge with the Ohio Civil Rights Commission before they can get into state court. And this process generally mirrors the EEOC or federal process that we're all used to. It also has absolved managers and supervisors from personal liability for actions that fall out or that are within the scope of their employment. So under existing case law in Ohio, managers and supervisors could actually be personally sued for their role in workplace discrimination or harassment. And this law, makes that no longer possible, except for if the manager or supervisor is acting outside the scope of their employment. It also streamlines age discrimination claims, which for some reason used to have a different process, a different statute of limitations, a different set of filing rules in order to bring age discrimination claims, and it has now aligned those types of claims with other types of discrimination claims. And finally, there is new damages caps. Well, there's not a cap on economic compensatory damages or lost wages. There are caps both on non-economic compensatory damages or emotional distress, and there is a cap on punitive damages as well. Okay, so that covers the new Ohio law. And then on the next slide, you will see we're going to be talking about the Chicago Predictive Scheduling Law. This is a law that also was in effect in July 2020, but is complex and sort of unique, so it's worth mentioning to make sure everybody's aware of, first, whether or not they're a covered employer and need to comply with the law, but second, if they are covered, what your obligations are under the law. So in terms of coverage, a covered employer is anybody with 100 plus employees globally, or 250 if you're a not-for-profit. But uniquely or importantly, 50 of those 100 plus or 250 plus employees must be covered employees. And this means that they're not an independent contractor. A majority of their work is physically performed in Chicago, and a majority of the work performed is for a covered industry. And they must earn less than or equal to $50,000 a year or $26 an hour. So if you've determined that you have, 50 or more covered employees, then you also, as the covered employer, must be primarily engaged in a covered industry. So what is a covered industry? Restaurants, building services, warehouse services, and manufacturing. So if you're sitting out there and you realize you're in a covered industry, then it's very important to make sure that you're paying attention to figure out whether you are a covered employer with covered employees. And if you've determined that you are a covered employer, it is important to understand what your obligations are, which we will cover on the next slide. Under the Chicago Predictive Scheduling Law, and if you're familiar with other laws around the country, a lot of this will, sound familiar, or hopefully you're familiar with what this law says too, if you are a covered employer. In terms of the different obligations, you must provide an initial estimate of the work schedule to employees. This must be before or upon beginning their employment, and it includes a good faith written estimate of the projected days and hours of work for the first 90 days of employment. There's not a requirement to update the estimate, but it must include average weekly hours expected to work, whether on-call shifts are expected, and any subset of days or times or shifts that employees can expect to work or not work. Employees also have the right to request modifications, and the employer must respond in writing within 3 days. The law also requires advance notice of work schedules, and currently it's at 10 days before the first day of the new schedule, but starting July 1st of 2022, it will be 14 days, and this notice must be in a conspicuous place, accessible and visible to all employees. The law also includes a predictability pay element. If the employer does not comply with the advance notice requirement, there are pay penalties. And there are certain exceptions to that as well that are helpful to pay close attention to. This law requires employers to offer work to existing employees. This means that the employer must first offer additional shifts of work to existing covered employees who are qualified to do the work. They don't have to offer it if doing so would require payment of overtime, which is important to understand. And if the hours are not accepted by
Hey, Meg, We lost you.
Yeah, Mike, I noticed that too.
I don't think she can hear us.
Okay, hold on one second. Ashley, are you there and ready to get going? I think we may need to hold on Meg here for a second.
Sure, I'm here.
I'll give Meg a call.
Okay. Why don't you, Julia, can you, I apologize to that, everybody, but if we could, yes, thank you. If we could go ahead and skip over, and then we'll come back to Meg. She's got a couple more things to round out. Apologies for the technical difficulty. Ashley, you want to take it?
Great, thanks. Sure, thanks, Erin, and good morning, everyone. My name is Ashley Cano, and I'm going to spend a bit of time here talking about the latest on return to work issues surrounding COVID-19. So next slide, please. So the question of whether to make the vaccine mandatory or voluntary is really one of the biggest questions that employers are struggling with right now. So there are both employment law considerations to take into account here, and then there also are labor law considerations as well. So on the employment law front, employers should consider both the Americans with Disabilities Act and Title VII of the Civil Rights Act. And on the labor law front, employers should consider the National Labor Relations Act. Next slide, please. So on the employment law front, one important thing for employers to consider is what the EEOC has to say. So on December 16th of 2020, the EEOC updated its COVID-19 Technical Assistance Guide, and this is the guide that the EEOC published toward the outset of the pandemic, and they've periodically updated it over time. And so they updated it on December 16th to address the issue of the COVID-19 vaccine. So importantly, the EEOC's guidance says that employers are always free to encourage employees to voluntarily get vaccinated. The guidance also provides that asking whether someone has been vaccinated is not a disability-related inquiry under the ADA, so that's helpful. But the guidance also provides that if employees say they have not been vaccinated, then the employer cannot ask any questions about why, unless the employer can meet the standard for the inquiry being job-related and consistent with business necessity. And I'll get more into that on the next slide, that standard. And then another important point in the EEOC guidance is that vaccines are not considered medical examinations for purposes of the ADA. So next slide, please. So the EEOC guidance also explains that employers can require employees to be vaccinated if the employees receive the vaccine from a pharmacy or healthcare provider that is not under a contract with the employer. And the stated reason for this is that pre-vaccination medical screening questions that employees are asked before getting the vaccine are likely to elicit information about a disability, which means that such questions, if they're asked by the employer or a contractor on the employer's behalf, those are considered disability-related inquiries under the ADA. And then the second requirement for employers who decide to require employees to be vaccinated is that the employer has to handle requests for accommodations for disability and religious-related objections to getting the vaccine consistent with applicable law. So, applicable law being Title VII and the ADA. And then on the other side of the coin, if an employer requires employees to receive the vaccine and the vaccine is administered by the employer or a contractor on the employer's behalf, which, as I said, means that the employer will be considered to be asking medical pre-screening questions, then the employer has to show that these disability-related screening inquiries are job-related and consistent with business necessity. And so to meet this standard, the employer needs to have a reasonable belief based on objective evidence that an employee who does not answer the questions and therefore doesn't receive the vaccination will pose a direct threat to the safety and health of others in the workforce, in the workplace. And so the question of whether a direct threat is posed largely depends on a number of factors individual to the case, such as the employee's level of contact with others in the workplace, how many employees are present. It's a very fact-specific inquiry. And the guidance also notes that responses to these vaccine pre-screening questions have to be kept confidential as required by the ADA. Next slide, please. So for employers who are going to mandate the COVID-19 vaccine, they need to be sure to handle accommodation requests consistent with applicable law, specifically Title VII and the ADA. So in the case of an employer that is planning to deny an accommodation request, the employer has to show that the unvaccinated employee would present a direct threat due to a significant risk of substantial harm to the health and safety of the employee themselves or others in the workplace that cannot be reduced by reasonable accommodation. And so this involves individualized assessments of the duration of the risk, the nature and severity of the potential harm, the likelihood that potential harm will occur, and the imminence of potential harm. And then it should also be noted that even if direct threat is found, an employee cannot be excluded from the workplace unless there is no reasonable accommodation that would reduce or eliminate the threat. And this important point here is this doesn't necessarily mean that the employee should or will be terminated because the employer has to also evaluate whether the employee can work remotely or whether they have some type of leave available to them. Next slide, please. So employers who mandate the vaccine, therefore, need to have an accommodation process for those employees who have disability-related or religious-related objections to getting the COVID-19 vaccine. So employers are required to provide reasonable accommodations unless doing so would present an undue hardship. And some potential accommodations in this arena would include requiring the unvaccinated employee to wear a mask, and also vaccinated employees to wear a mask. Requiring periodic testing for the employee who has declined vaccination, enforcing and implementing social distancing protocols, staggering employees' work schedules so that employees who are unvaccinated are not having as much interaction with other employees. Again, considering whether the employee can work remotely effectively. And another potential accommodation would be transferring the unvaccinated employee to a non-public facing role. But questions can arise there. Well, is that change to that other role and adverse employment action? So, that's also something that would need to be considered. And then it's also important to know or remember that the standard for undue hardship is slightly different under the ADA for disability-related objections versus Title VII for religious-related objections. So under the ADA, the standard for undue hardship is that the accommodation would present the employer with significant difficulty or expense. Whereas under Title VII, the employer just has to show that the accommodation would present more than a de minimis cost or burden. So it's a slightly easier standard under Title VII for religious objections. And employers should really consider in deciding whether to grant an accommodation the prevalence of employees in the workplace who have already been vaccinated and the amount of contact that the unvaccinated person would have with those whose vaccination status is either known or unknown. And in terms of the documentation that employers can ask for with respect to religious accommodation requests related to the vaccine or disability-related requests, accommodation requests related to the vaccine, so employers can ask for documentation from the employee's medical provider on the medical necessity to be excused from the vaccine. And then for religious accommodation requests, employers can ask for documentation from the employee or their clergy related to their objections to the vaccine. Next slide, please. And then I finally wanted to take just a few minutes to talk about the labor law considerations in this arena. So as I'm sure many of you know, the National Labor Relations Act imposes on employers a duty to bargain in good faith with employees' union representatives. And this includes a duty not to make certain changes without bargaining with the union. So, this is really only relevant to unionized employers at this point, but I will have a couple of points related to non-union employers in this space too. So this duty to bargain in good faith under the NLRA means that for unionized groups of employees, employers should look at their applicable collective bargaining agreements to determine the extent of their duty to bargain with the union over a COVID-19 vaccine program. Generally speaking, even if a collective bargaining agreement has a broad management rights clause, probably not going to extend broadly enough to give the employer the unilateral right to implement these programs without discussing them with the union. And then, for employees who aren't currently represented by a union, employers should still consider how instituting a COVID-19 vaccine program might affect any applicable union avoidance strategy. So, the main point to remember here is that when employees feel as though their employer isn't listening to their concerns or adequately communicating with them, they're more likely to turn to labor unions for help. So employers should therefore be asking themselves, well, could the positions that we take regarding a COVID-19 vaccine program, whether we decide to make it mandatory, voluntary, could those positions change employees' views on the potential benefits of bringing in a union or give union organizers sort of more ammunition in their efforts to organize employees? And then employers may also want to consider, to what extent are we going to consider employees' concerns about efficacy, side effects, or just, general fears about or aversions to vaccines, and, how are we going to communicate with employees about those concerns? And then employers may also want to ask themselves, well, how are we going to balance the concerns of employees who resist the vaccine against employees who want everyone in the company or the facility to get vaccinated? And, should the employer maybe consider alternatives, such as the option to wear a face mask or get periodic testing, things like that. And so aside from, sort of the collective bargaining agreement and then union avoidance pieces of this, both union and non-union employers should also be mindful of Section 7 of the National Labor Relations Act. So that section protects employees' rights to join together to advance their interests as employees and makes it unlawful for employers to interfere with or restrain employees in the exercise of those rights. So if employees join together to protest an employer's COVID-19 vaccine program or something about that program, and the employer takes adverse action against those employees as a result, it could very well lead to unfair labor practice charges being filed against the employer with the National Labor Relations Board. So thank you. I'm going to go ahead and toss it over to Alex to talk about the Illinois Biometric Information and Privacy Act. Thank you.
Great, thanks so much, Ashley. Hi, everyone. Thanks again for joining this morning. Like Ashley said, I'm Alex Ofccp, and I'm going to talk a little bit about the Illinois Biometric Information Privacy Act, or what we fondly refer to as Bipa, and what to expect in 2021. So I'm going to do kind of a brief overview for those of you who may not be as familiar with Bipa. I assume many of you have dealt with Bipa in the past, or unfortunately have dealt with some Bipa litigation. But we're going to do a brief overview and then get into some updates and what to expect in the coming year. So next slide, please. So where did Bipa come from? It was passed in 2008, so it's a little bit older than people expect. It was motivated primarily by the bankruptcy of Pay by Touch, which was the largest fingerprint scan system in Illinois. There had been a lot of news reports coming out around that time about data breaches in other countries that implicated biometric information. So in light of all of that information and this bankruptcy, the legislature passed Bipa. The legislative history surrounding the bill suggests that the statute was implemented primarily to protect consumers. But as we're going to talk about today, it has vastly exceeded that scope in recent years. Generally, it regulates the collection, use, safeguarding, handling, destruction of biometric identifiers and information. And we'll talk a little bit about what that means. But as kind of a caveat, and you'll hear me say this throughout the presentation today, it has only recently generated litigation. So courts are still interpreting Bipa. There are a lot of holes in the statute, so there are still a lot of unknowns relative to the law. Next slide, please. So the rise in
Oh dear. Seems that we may have, Alex may have, this is,
We lost Alex.
we did.
difficulties.
There you go. Okay, Alex, sorry, we
can you
lost you
hear
for
me?
just once. We did. You're back. Thank you.
Okay, perfect. Sorry about the technical difficulties today. So beginning in 2017, there was kind of this big rise in Bipa litigation. Plaintiffs' attorneys discovered that Bipa provides for certain and possibly significant penalties and attorney's fees. And so they kind of started filing en masse these Bipa litigation cases. And it became kind of a gotcha litigation for employers. A lot of Illinois companies and employers were caught out of compliance with the law. and had to settle out these suits for sometimes significant sums. So over the last approximately 2 years, about 1,076 cases have been filed under Bipa against Illinois companies, which is really a significant number. That's only increasing, it's only getting more popular. It's covering all industries: hospitality, manufacturing, healthcare, retail. Non-for-profits have been getting hit with Bipa litigation. So really no one is safe. And they've also been suing the manufacturers and vendors of these kind of biometric scanning systems at issue as well. So it has become a significant area of litigation in Illinois. Next slide, please. So who is covered? Like I just said, pretty much everyone. Bipa covers private entities in Illinois, and private entity means any individual, partnership, corporation, LLC, association, or other group, however organized. There are very few exceptions to entities or individuals not covered by Bipa. So it doesn't include the state or a local government agency, a court of Illinois, a clerk or judge of that court. Certain financial institutions are exempt, or contractors, subcontractors, or agents of state agencies or local units of government, when working for that state agency or local unit of government, can also be exempt by Bipa. That caveat or carve out from Bipa has seen very little litigation, so it's unclear how broad the scope is of when you're working for that state agency or local unit of government. But if you are a contractor or subcontractor for the state, keep that in your back pocket in case you're ever hit with this kind of litigation. Next slide, please. So what is a biometric identifier? That's an expanding scope. It's a little bit of an amorphous definition, but I'll go through the big four quickly. It's a retina or iris scan. Those almost always qualify as biometric identifiers. Fingerprints are the #1 litigated area where employers or companies in Illinois
Alex, you seem to have zapped out again. I apologize, folks. Those of you listening in, I do apologize for the technical difficulties this morning.
Biometric identifiers. The most popular case, or the most high-profile case in that area, was related to Facebook. They got challenged over their photo tagging suggestion feature, where they would scan photographs uploaded to Facebook and suggest that you may want to tag someone because it looks like they're in this photo. Facebook settled their lawsuit under Bipa related to that feature just in the past year for $650 million. They initially tried to settle for $550 million, and the judge rejected the settlement, saying it wasn't good enough. So they increased it by another 100 million. But I think some employers do have certain features relative to their time clocking systems, such as like a buddy punch scanning system where photos of employees are taken by the time clock system. They're compared to other photos to make sure that the person clocking in is who they say they are, and that could implicate Bipa. So be wary of the facial geometry biometric identifier definition. Bipa also includes a lot of examples of things that do not qualify as a biometric identifier, which helps narrow it down. But like I said, it's sort of an evolving definition. Next slide, please. So how to comply. I'm going to go very quickly through these slides about sort of compliance efforts. I will say, if this is the first that you're hearing of Bipa and you think that you may be, or your company may be, doing things that implicate the law, I would strongly encourage you to reach out to your Seyfarth contact or counsel to start working on how to get into compliance, or whether you need to be in compliance. Like I said, this is a high litigation area. It's kind of a hotbed in Illinois for high profile and high dollar value lawsuits. So just make sure that if you're not familiar with these, you kind of reach out to counsel and start working on it. So first, Bipa requires that if you possess biometric information or identifiers, you develop a written policy that establishes a retention schedule for that information and has guidelines for permanently destroying those identifiers or information. That policy needs to be made available to the public. That's a very important piece of this. And then you need to comply with that retention schedule and those destruction guidelines absent a valid warrant or subpoena in a lawsuit. So just make sure that you are familiar with what this policy needs to say and that you have it on the books if you possess biometric information. Next slide, please. So the next requirement, and this is really the heart of Bipa, it lays out the consent requirements if you're going to collect someone's biometric information or obtain it through any means. That consent needs to be collected before you get the biometric information.
Looks like her internet's going in and out here.
Yeah.
Think that they're in compliance with Bipa and then to find out that the timing of when they got the consent led to liability. So make sure that the order in which you are enrolling individuals in a time clock system or other kind of scanning system and when you're getting that consent match up so that you're still in compliance with Bipa. Next slide, please. Additionally, that written release, it needs to be, for employees, needs to be considered a condition of employment. It's a very vague phrase under the law. And all I'll say about that is if you have employees who start refusing to sign these consents, reach out to your counsel to come up with some crafty way to kind of get around the Bipa elements of that to make sure that you're still in compliance. Next slide, please. Some other requirements, you can't profit off of someone's biometric information that you obtain, don't sell it to a third party, you lease or trade it in any way. If you are going to disseminate it to a third party, there are additional consent and disclosure requirements for that. This is something where you need to be in close contact with a payroll provider or the vendor who provided you with the software or hardware for these scanning systems to make sure that the system is not sending the biometric information to them without your knowledge. A lot of employers have been caught unaware that their payroll provider has been collecting that biometric information from them, and then they start to run afoul of Bipa in this area. So it requires a lot of knowledge about where the data is going, what your vendor is collecting, and if that is being transmitted to some vendor you have, to make sure you comply with these requirements. Next slide, please. And finally, Bipa requires that you keep that information, that biometric information, confidential using a reasonable standard of care. If you have some concerns about how you're storing biometric information, again, I would encourage you to reach out to counsel to make sure that there isn't an issue there that's going to give rise to litigation. Next slide, please. Okay, so why does this matter? That was a lot of information. Why is this such a hot topic for litigation? So like I said, Bipa provides some very specific statutory penalties. So for example, if someone gets caught negligently violating Bipa, some employer or corporation in Illinois, it's $1,000 for each negligent violation or actual damages. And if you're willfully or intentionally or recklessly violating Bipa, it's $5,000 per violation or actual damages. The law also provides for injunctive relief and reasonable attorneys.
Okay, folks, I think Uma and Christine, if you guys are up or available, we may want to. Alex, I'm sorry. We had some technical difficulties with you. I apologize. I'm just, I don't want to cut you off at all, but I do want to move.
Sure.
If we can. Do you have just a few more minutes?
I do, just a couple more minutes.
Great.
Let's move to the next slide. Just be aware of these kind of statutory penalties. So here's kind of the hot topic, Bipa in the COVID era. A lot of you have likely been rolling out new technology to either help keep employees safe in the workplace or to help them work from home. all I'll say about the new technology, you need to do a very careful due diligence on any new technology you're rolling out for employees or customers. You need to understand its capabilities, and that may mean conversations with the vendor to make sure that it is not implicating Bipa somehow. So for temperature taking technology, if it is doing some kind of facial scan to take someone's temperature, that might implicate Bipa, and you need to talk to your vendor or counsel about that. If you've rolled out new laptops and you are requiring employees to do a fingerprint to get into the laptop for security purposes, that likely implicates Bipa. So anytime you roll out new technology, it's going to be important for you to understand what are the capabilities of that technology, what capabilities are turned on, what is the technology doing, is it transmitting the data somewhere, and making sure that you are fully understanding the implications under Bipa. Next slide, please. Okay, so what are the defenses of Bipa? There are several. A lot of them are still being litigated and are undetermined. In the next year, we will likely understand more of the defenses that are available, sort of interpreted by case law. But the number one defense is compliance. Even if your compliance efforts are not quite up to Bipa standards, that helps us avoid maybe a finding that you were negligently violating Bipa. So any compliance efforts help, but really robust compliance and working with your counsel on compliance is always the best strategy. Okay, next slide, please. Okay, and finally, what are we going to expect in 2021 relative to Bipa? Last week, the Illinois Judiciary Committee advanced a House bill proposing significant changes to Bipa that would really undercut these litigation efforts under the law. So that House bill provides that anyone who wants to bring a lawsuit under Bipa needs to give a 30-day notice to the entity they want to sue, and then that entity would then have 30 days to get in compliance with Bipa. Otherwise, that litigation can go forward. That would really undercut this sort of gotcha element of, and at least Illinois corporations a fighting chance to get into compliance with the law. It would also limit the damages under Bipa to actual damages. It would get rid of that $1,000 and $5,000 penalty provision and only provide for actual damages or actual damages ×2 for willful violations. So that's going to be something that anyone who's collecting biometric information is going to want to keep an eye on. Second, a lot of states have proposed laws similar to Bipa. 3 states already have Bipa-like laws, California, Texas, and Washington, though they are different in the private right of action area from Illinois. But at least 13 other states have introduced legislation similar to Bipa about biometric privacy, and there's also been a push for federal legislation. So keep an eye on where you're operating to make sure that similar laws are not being passed. Portland and New York City have also passed biometric privacy laws that do provide a private right of action in the last few weeks. So if you are operating in those cities, make sure that you are in compliance with those laws. And finally, depending on what happens with Bipa and this new House bill and the new case law that's been coming out in that area, plaintiffs' lawyers might start looking at what I call Bipa's cousin, GIPA, which is the Genetic Information Privacy Act. This could be another sort of gotcha law that employers are collecting genetic information and not realizing it. So make sure that you're familiar with GIPA, whether you are in possession of genetic information as part of maybe an employee wellness program, and get in compliance with that law before it becomes a very hot topic, because it does provide kind of more robust statutory penalties than Bipa. And with that, I'm sorry about the technical difficulties. I'm happy to answer any questions during the Q&A section, but I'm going to turn it over to Uma and Christine to talk about diversity, equity, and inclusion.
Thanks, Alex. As Alex mentioned, I'm Uma Chandrasekaran. Christine Hendrickson and I are going to shift gears a bit now and talk about diversity, equity, and inclusion issues to have on your radar given the new administration in the White House. Next slide. So I want to begin by talking about a couple of the Trump administration initiatives because they really put into context what the Biden administration is focused on regarding diversity, equity, and inclusion issues. So in September last year, as many of you know, Trump issued two fairly dramatic pieces of policy implementation. First, in early September, Trump issued an OMB memorandum, which directed the federal agencies that conduct federal training to not discuss issues like white privilege or make assumptions about embedded racism in the US as part of their trainings. So this would have included concepts like implicit bias. That was followed by an executive order in September, later in September, on September 25th, which forbid government contractors as well as federal agencies from using race or sex stereotyping as a basis for training and policy. The executive order repeated much of what was in the OMB memorandum, but it also directed the procurement agencies to collect, though it was voluntary on the part of the contractors, the training materials to review them to determine if they contained the information that the Trump administration deemed was improper. And in a really unusual move, the executive order directed the Justice Department to interpret Title VII consistent with the policy in the executive order. Then a few days later, on September 28th, the Ofccp announced that it had created telephone and email hotlines for employees to report, quote, offensive and anti-American race and sex stereotyping and scapegoating in light of Trump's executive order. All of this caused a lot of anxiety in the federal contractor community because a lot of the training had already been booked for the year. And a lot of trainings talk about concepts like implicit bias that were now being banned from being discussed. This resulted in a number of challenges to the executive order by civil rights organizations like the NAACP. And then in December, a U.S. District Court in California issued a nationwide preliminary injunction stopping the enforcement of the executive order. Next slide. Now, fast forward to January 20th of this year, the first day Biden was sworn in, he signed several executive orders, and two that are particularly relevant to diversity, equity, and inclusion issues. So Executive Order 13985 rescinded the Trump executive order, and the Biden executive order requires really the polar opposite. Now federal agencies are required to promote diversity in training and policy. And it directs that the Domestic Policy Council, which is an agency out of the White House, take the lead in ensuring that federal agencies emphasize diversity, equity, and inclusion in training and enforcement policies. Also on January 20th, Biden signed Executive Order 13988, which is aimed at protecting LGBTQ individuals. And so this executive order directs each federal agency to review all existing guidance endorsed or administered by that agency under Title VII and identify any guidance that is or may be contradictory with this executive order. It also directs that within 100 days, so that would be the end of April, the head of each government agency should build and deliver a plan to carry out actions that align with this executive order. And then most recently last week on March 8th, Biden signed an executive order establishing the Gender Policy Council within the White House. And this is a reformulation of an office from the Obama administration that had been disbanded by the Trump administration. And this council is tasked with implementing policies and programs to combat systemic bias and discrimination, including sexual harassment. And it's specifically tasked with addressing structural barriers to women's participation in the workforce, wage and wealth gaps, and caregiver needs in families. What's interesting about one thing that's interesting about the executive order is that it specifically recognizes that the COVID-19 pandemic has disproportionately affected women and directs the council to draft recommendations to specifically address these effects. And the council is supposed to especially consider the experiences and needs of women in underserved communities. Under this executive order, the council is to develop and submit a strategy to address each of these concerns within 200 days of the order. And each year thereafter, the council is supposed to submit an annual report advising the president on the progress achieved in implementing the strategy. So in the first 60 days, it's clear that the Biden administration has set a tone that it's prioritizing issues around diversity, equity, and inclusion. I just want to know, these are all executive orders that we've talked about, which are legally enforceable, but they can be reversed. So 4 years from now, depending on the next presidential election, we may be looking at a very different landscape. Next slide. Now, as we've been discussing, we're seeing a lot of activity from the Biden administration surrounding the issue of equitable wages. And one of those issues is the minimum wage. And this issue has gotten a lot of coverage in the media. And I want to talk about both what's been going on in terms of executive orders as well as congressional action. So on the executive order side, Biden signed Executive Order 14003 on protecting the federal workforce on January 22nd. It requires the director of OPM to make recommendations regarding establishing a $15 minimum wage for federal employees and federal contractors. Currently, the federal contractor minimum wage is $10.95, which was established under President Obama. Biden has directed his administration to start the work that would allow him to issue an executive order within the first 100 days, requiring federal contractors to pay $15 minimum wage and to provide emergency paid leave to workers. So we'll have to see. Again, 100 days would put us at the end of April. So we'll keep everyone posted and be monitoring that. On the congressional action side, there was a lot of press coverage around the COVID-19 stimulus package having a $15 minimum wage as part of it. That effort failed because the Senate parliamentarian ruled that the wage hike didn't meet the criteria to be included in the bill under the special reconciliation process. So that path is now closed. But House and Senate Democrats have introduced standalone legislation called the Raise the Wage Act of 2021 to increase the federal minimum wage to $15 by 2025. We'll have to see whether the $15 minimum wage legislation will get the support it needs to pass. Many moderate Republicans who are open to raising the minimum wage have signaled that they are opposed to raising it to $15 and that it doesn't take into account geographic differences and considerations. Bottom line, the number might change, but employers should expect some kind of increase in the federal minimum wage during the Biden administration. And I just want to remind everybody, for those of you who are in Illinois, there's already legislation in place since 2019 to gradually raise the state minimum wage to $15 by 2025. With that, I'm going to turn it over to Christine Hendrickson, who's going to discuss in more detail what we can expect to see from the Ofccp.
Wonderful. Well, thank you so much, Uma. Uma talked about there's been a change of tone, and that is not more clear than what we're seeing with the personnel changes that are happening at the Department of Labor. So at the very top, President Biden nominated Marty Walsh to serve as the Secretary of Labor. He is an organized labor veteran. He was the head of the Boston Building and Construction Trades Council before entering public office. He was elected to be the mayor of Boston in 2013. And then following his service, he headed the Building Trades Council, a coalition of Boston area unions. So he has a long union background. And so we're going to see that more and more within the Department of Labor. Within the Ofccp, there's also been a new leadership change. Jenny Yang is the new Ofccp director, replacing Craig Lean. She served as the EEOC chair during the Obama administration. And when she was at EEOC, she led the charge on the EEO1 pay report. She also spent over a decade handling complex employment discrimination and wage and hour cases when she was a partner at the plaintiff's firm of Cohen Milstein. And before that, she was a senior trial attorney at the U.S. Department of Justice in the Civil Rights and Employment Litigation section. So she has a long history beginning right when she graduated from law school, where she was at the National Employment Law Project as a fellow. So we're talking about someone who has a lot of experience working with the government and a lot of experience on the class and collective action side. So while it's too soon to know exactly what Director Yang's priorities will be at the OFCCP, from her tenure at the EEOC, it is highly anticipated that she will focus on pay equity, both potentially bringing back reporting obligations for federal contractors, and also working on systemic pay cases. There's also some evidence that she may be focused on the use of artificial intelligence in recruiting, and then of course on sexual orientation and gender identity rights. So we expect it to be a very busy next 4 years in the OFCCP. We've already started to see some changes in Jenny Yang's short tenure with a significant shift and emphasis towards audit strategy. Under Craig Lean, the former director of OFCCP, there was a lot of focus on education and compliance, and we're seeing that shift away from education and compliance straight into enforcement. How have we seen that? It's really been two main actions that we've seen so far that we're kind of reading the tea leaves on. The first one is that in an incredibly rare move, she actually removed audits from the corporate scheduling announcement list, or the CSAL list, for supply and service contractors. The OFCCP announced that it wanted to remove these audits to allow them to more thoroughly evaluate contractors through strategic allocation of limited agency resources. So what happened? Okay, so on September 11th, 2020, under the Trump administration, the director, Craig Lean, issued over 1,750, actually exactly 1,750 audits that fell into certain categories. And that full list, that full CSAL list, was 2,250 reviews. It was thought at the time that it's unusual for an administration to, right at the end of the tenure, release such a significant number of OFCCP audits, and especially in the way that they were allocated. So of the 1,750, 1,250 of those were focused reviews. So there were 250 that were Section 503 focused reviews. And then there were 500 that were either accommodations or promotion focused reviews. And then there were an additional 500 compliance check audits that were issued. So the recension of these 1,250 focused reviews will really have really significant impacts, because it means that all of these compliance checks were these really kind of quick in and out audits. And even these focused reviews that were focused on things like accommodation and Section 503 compliance, key priorities of Director Lean are not going to be moving forward. I wanted to note that the construction compliance checks are going to continue, and OFCCP is still working its way through lists that were on prior lists prior to the September 11th, 2020. So there's still audits that have not been scheduled that were on the 2019 list, for example, and all of those audits are going forward. But if you were a contractor that had a focused review under Section 503 that was on that September 11th CSAL list, or if you had a compliance check or an accommodation or a promotion focused review. Those have all been rescinded. And so you may want to check the CSAL list to see if you were one of the ones, if you were an organization where your audit was now rescinded. And so while this is really good news for some individual contractors who had an audit that was scheduled that is no longer scheduled, it does suggest that the OFCCP is going to be laser focused on enforcement, because instead of having the OFCCP focused on doing these kind of in and out audits where it's highly unlikely that there would be any monetary fine associated with those OFCCP audits, this opens up OFCCP to doing more and larger OFCCP audits that could potentially lead to a monetary penalty. It also allows the now leaner OFCCP. OFCCP has fewer compliance officers than it's had in any time in recent memory. And so they're working with far fewer compliance officers. And so this enables them to work through audits, kind of more traditional OFCCP audits, without learning the ins and outs of how to conduct a promotion-focused review or an accommodation-focused review, and again, suggests that the OFCCP is going to be very kind of focused on compliance. Second, the second thing that we've seen so far in—
Christine, I'm sorry, Christine, let me just stop you real quick, because it is at the bottom of the hour. And so for those folks who may need to leave, we do need to read out the CLE code. And that is, and then we'll let Christine finish and run back to Meg. The CLE code for today's session is SS, so Seyfarth Shaw, SS 8102. Once again, it's SS 8102. Christine, sorry about that. Thanks.
No, thank you so much, Erin. I appreciate it. Yeah, so the other thing I just wanted to mention quickly is that on March 1st, OFCCP took down the contractor assistance portal. So the former OFCCP Director, Craig Lean, made a hallmark of his tenure transparency. And he announced in August 2019 that OFCCP was going to put up this contractor assistance portal that would allow contractors to ask questions without attribution, to search frequently asked questions, and to access reference and compliance assistant materials. So again, this focus, this signals kind of a more enforcement focused OFCCP, and one that is not as kind of compliance or transparency focused OFCCP that we saw under Director Lean. So really stay tuned as we hear more about the direction of the OFCCP and the priorities that the agency undertakes under Jenny Yang's leadership. It really does promise to be quite interesting. I also wanted to briefly mention that the changes at the OFCCP are also reflected in the actions of other agencies, again, suggesting more of a commitment to DE&I issues as we move forward. The Trump administration's Department of Justice brought a lawsuit against Yale in October, claiming that Yale's admissions policies discriminated against Asian American and white applicants and created preferences for Black and brown applicants and for some other Asian applicants. This was really kind of unique litigation. You may recall that there was previous litigation involving the University of Michigan Law School, my alma mater, go blue, where admission policies were challenged in the early 2000s on the basis of racial preferences. So in the Grutter versus Bollinger Michigan suit, the Supreme Court upheld the holistic use of race and economic deprivation and other standards to permit as permissible concepts that can be used in admissions. So the lawsuit against Yale was a direct attack on those decisions. In Princeton, with respect to Princeton, the Trump administration directed the U.S. Department of Education to investigate all of Princeton's diversity and inclusion actions. So they were looking at not only admissions, but also hiring practices, training, and other practices that were designed to bolster DE&I efforts. So again, a very unique situation. In February, the Biden administration dropped its suit against Yale, without much fanfare in a 2-line notice of voluntary dismissal, and has now also closed the investigation against Princeton. So that we're seeing that, as you can see, kind of a very different administration just in these short months on a lot of action on the DE&I front. So I'm going to toss this back over to Meg to continue. Thank you so much for your time today. So take it away, Meg.
Great. Thank you, Christine. And I guess that serves me right for congratulating my muting abilities. Got completely cut off. So anyhow, I think we were somewhere in the midst of the predictive scheduling laws, but for purposes of efficiency, we're going to start up on the ban the box clause, which I think is slide 13. Perfect. And if anybody has questions about the Chicago predictive scheduling laws or the new legislation in Illinois, we are happy to answer any of those questions. Alrighty, so for ban the box laws, there are 2 new laws and 1 potential amendment to an existing law in Illinois. So in St. Louis, there's a new ban the box law. And when I say ban the box law, this refers generally to laws that provide certain protections to employees and or applicants with criminal histories or arrest records. And these laws, which we assume you've heard of, are all over the country. So the new ones in the Midwest are St. Louis, and St. Louis was became effective on January 1st of 2021. It applies to any employers with 10 or more employees. And it prohibits employers located in the city of St. Louis with at least 10 employees from basing hiring or promotion decisions on an applicant's criminal history unless the employer can demonstrate its decision is based on available information, including the frequency of the criminal record, the recency of the criminal history, the recency of the convictions, the severity of the criminal history, and it has to be reasonably related or bear on the duties and responsibilities of the position for which they have or which they're applying. And under this law, employers cannot require disclosure of criminal history on applications or early hiring stage forms. They must wait until the final selection round to ask all candidates, they must ask all candidates in the final selection pool if they're going to be asking that information. There's also a new law that went into effect last year, July 1st of 2020 in Waterloo, Iowa, that applies to employers with 15 or more employees. And this law just basically says that the employers cannot inquire about criminal history until a conditional offer of employment is made. There is an exception if the information is voluntarily disclosed. And in terms of making these inquiries after a conditional offer of employment, the offer of employment can only be rescinded for legitimate reasons, which are specifically set forth in the law. So very important to pay close attention to that when hiring or if you have employees in Waterloo, Iowa. And finally, the last related law we wanted to talk about was in Illinois, and there is going to be a potential, or there potentially will be an amendment to the existing law. As many of you guys are probably aware, Illinois currently has a ban the box law restricting employers from asking about criminal history generally until after an interview. And it does have laws which make it unlawful for employers to take action against an applicant or employee based solely on the fact that they have been arrested for a crime. Under this new amendment that was introduced on February 5th, which is under Senate Bill 1480, if signed by the governor, Illinois employers risk an additional civil rights violation if their decision to take action against somebody with a conviction history does not conform to this heightened substantial relationship standard in the bill, which means that they must be able to show that there is a substantial relationship between one or more of the previous criminal offenses and the employment being sought or held. And this substantial relationship means a consideration of whether the employment position offers the opportunity for the same or a similar offense to occur, and whether the circumstances leading to the conduct for which the person was convicted will reoccur in the employment position. Or the granting or continuation of the employment would involve an unreasonable risk to the property or safety or welfare of specific individuals or the general public. So we will see. We think that law is likely to be passed, but we shall see. So that is my portion here regarding just general Midwest updates. Thank you again for your patience and the technical difficulties. And I will turn this back over to Erin to wrap up.
Thanks, Meg. Yes, so we do have a couple of questions. And the first one is actually about the Chicago Predictive Scheduling Law, which is, I think, where we may have dropped. But the question is for the audience is to confirm that the Chicago Predictive Scheduling Law referencing work performed in Chicago means within the city limits of Chicago. Does that, I'm gonna let Meg toss that one to you.
Perfect. Yes, that's what it does mean. It means performed within the city limits of Chicago. Doesn't apply more broadly than that. So that was a pretty straightforward question.
There you go. Another question for Meg regarding the Illinois sexual harassment reporting. The question is whether if we have remote employees working in Illinois, are you required to file the report that you were referencing?
Yes, so it does. I mean, I guess this is one of those lawyerly it depends responses in terms of the nature of the remote work and the arrangement with the employee. But if the employee is a remote worker that only performs work in Illinois, then most likely they will qualify as somebody that brings you within the coverage of the law and your obligations under the law to make those reports.
And another reporting or compliance question, the question is the training and reporting a requirement for local governmental agency or entities in Illinois as well as for private entities?
Yes, that's correct. So the law itself doesn't make a distinction between governmental entities or private entities in terms of the training and reporting requirements. There are different training requirements, though I will say for bars and restaurant employers. I guess that's sort of unrelated to the question, but there are different standards there, as well as for employers who are parties to public contracts within the state of Illinois. There are additional policy requirements related to sexual harassment there. But for purposes of the training we discussed and the reporting requirement that we discussed, it does apply to governmental entities in Illinois as well as private entities.
If there's nothing to report, are Illinois employers still required to file the report?
If there is nothing to report, I don't believe so, because the requirement only applies when there is an adverse or administrative ruling or judgment to report. So, to be determined, because the law is so new, perhaps we'll get guidance that says otherwise. But right now, most clients are taking the approach if there is no rulings to report, then they're not required to report them.
And are those just related to claims of sexual harassment and gender, or is it to all other forms of adverse decisions?
Yeah, this generally applies to adverse administrative rulings or judgments that find sexual harassment or any unlawful discrimination.
So it would be broader than just sexual harassment claims. Okay.
Yes, yeah, it includes harassment or discrimination on the basis of race, color, national origin, religion, all those different protected statuses that are protected under Illinois law.
Got it. And it looks like we've got one or two final questions. Sorry to monopolize all of Meg's time, but I think these came in early in the program. Does the Chicago Predictive Scheduling Law apply to staffing firms or temporary employees who are assigned to work in a covered industry?
Yeah, so generally the law does not apply to independent contractors or a worker for a day or temporary labor services agencies. However, if the day or temporary labor does it has been on assignment for a certain period of time, which I believe is 420 hours within the last 18-month period, then they are covered. They are considered a covered employee.
Great, thank you. Two quick questions that came in just a second ago, both related to Alex's topic. Alex, are you back with us?
I'm here. Can you hear me?
Hello. Yes, excellent. Could you give our audience an example of what constitutes actual damages as it relates to the Bipa statute that you discussed?
Sure. So actual damages would be, for example, if you were to collect biometric information and your safeguarding of that information led to a data breach and the employee or individual whose information you collected suffered some harm from that breach. For example, someone got a hold of their fingerprint and used it to enroll in programs that were detrimental to them or something of that nature. Those would be considered actual damages. So any actual harm that can be tied to your collection of biometric information, that's what would be covered by actual damages.
And that's part of the statute that's still kind of being figured out at this point within the litigation that's occurring, correct?
Yeah, that's right. For the most part, plaintiffs' attorneys generally will concede there are no actual damages. So you could collect actual damages under Bipa currently, and a lot of times they just concede that there were no actual damages here. They're going for those statutory penalties. Under those proposed amendments, that actual damages definition will become a lot more important if those were to pass.
So wait and see, TBD.
Yep, TBD.
And then one other question for you, Alex. Could you give us an overview of the GIPA, G-I-P-A, the Genetic Privacy and Wellness Programs? It might be a little too diverse on the question, but certainly we can get our question, or we can get some information on those as well. So.
Yeah, absolutely. And, you know, we could spend another presentation talking about GIPA, certainly. But generally, GIPA will cover genetic information kind of as it's defined in other federal law. So you may be familiar with GINA, which is the Genetic Information Non-Discrimination Act, which is enforced by the EEOC and is kind of a discrimination law. You know, anything defined by GINA will be covered by GIPA. But one of the specific provisions of GIPA cover employers collecting that kind of genetic information under wellness programs. And that could be, you know, kind of history of mental illness, you know, asking questions, asking for employees' medical backgrounds, kind of family history for medical backgrounds. That's something that also was sort of kind of a red alert under COVID early on. The EEOC warned about collecting information that may implicate GINA.
Sorry, Alex, we lost you for just a little bit. I'm going to jump to the next question. This is for Ashley. Can you ask if...
Oh, did I cut out?
Sorry, Alex.
No problem. Sorry about that. I'm not sure what's going on.
Well, you know, it's 2021, so.
Right. If you have employer-run wellness programs asking employees for any kind of medical background, family history, anything along those lines, you're going to want to take kind of a close look at GIPA and make sure that you're not implicating anything defined in that law.
Thank you, Alex.
Sure.
Ashley, going to go back to you on a vaccine question that just came in. Hold on one second, my computer moved. Essentially, the question is, if an employee has been vaccinated, can that information be kept confidential, or is that somehow, does that need to be recorded in some way by the employer?
Sure. So yeah, so under the EEOC guidance, employers are allowed to ask employees if they've been vaccinated, and I would recommend, you know, sort of keeping those responses confidential as a best practice. But what the EEOC guidance also says that, you know, if in response to asking an employee whether they've been vaccinated, if the employee says they have not been vaccinated, then the employer can't ask questions about why, unless the standard for job-related and consistent with business necessity is met, because then that is considered a disability-related inquiry.
Okay. Thank you for that. And then, Alex, just one more back to you. I think you touched on it briefly in your core presentation, but does the facial thermometer checks fall under Bipa and particularly if this process excludes the collection of names. Does that question make sense?
Yeah, that's a great question. I'm going to also give the lawyerly answer of it depends, and it depends very much on what the technology is doing. If it's just, you know, a little thermometer held up against somebody's head, taking their temperature, that's likely not going to fall under BIPA. There are some more advanced technologies rolling out where there may be kind of facial scans going on to tell temperature, maybe identify the employee. And those could start to implicate BIPA, even if it excludes collecting names. If there's any way that it can be tied to any employee or it's kept in record somewhere, even performing that scan, you're going to want to take a look at BIPA. The quickest way to really find out exactly what it's doing is just to talk to your vendor. They should be able to give you kind of an overview of what the technology is doing. And some may even caution you about whether they think it might run under BIPA or not. So that's probably the first place to check. You know, if they start to get a little bit hesitant about talking about it, you may want to check with your counsel about what they tell you and whether or not it's better to be kind of safe and roll out those BIPA compliance requirements.
Thank you, Alex. All right, let me just scan the questions here. I think we've gotten through all of them that people have asked. Let me just, for those of you who were kind enough to stick around, let me read the CLE code again. It's SS Seyfarth Shaw 8102. And it looks like we've covered all of the questions. Just as a reminder, you will be getting copies of the presentation. The presentation was recorded, so if you've got colleagues that you want to have come back and listen to it as well, that will be available. We appreciate you all spending an hour or so with us this morning, and thank you again. We really greatly appreciate your time, and we'll see you in Q2 for the next breakfast briefing, someday back in the office. So have a great day, everybody. Take care.